This is case number 18-145625. This is Johnson Financial Recovery Group versus Edwin Jones. The matter is before the court on petition in order to show cause. Your appearance for Johnson Financial Recovery, please. Counsel for Johnson Financial Recovery. Do I have Edwin Jones on the Zoom? If you're on the Zoom, please say something, Mr. Jones. All right, it appears that the petitioner regarding this matter has not appeared. The motion for show cause will be denied at this time. The court now calls case number 22-189-725. This is Henry Ford Health Systems versus Michigan Assigned Claims Plan. The matter is before the court, set on for a hearing on today's day. It looks like I have in fact received the answer to the complaint, and this may very well be the first hearing in this regard. Your appearance at this time for the plaintiff, please.
Good morning, Your Honor. Paul Millenbach, P42795, on behalf of the plaintiff, Henry Ford Health System.
All right, thank you, Mr. Millenbach. Thank you for your patience. We're a little behind today, and good morning to you, sir. For the record regarding Michigan Assigned Claims, please.
Your Honor, Eric Duenas on behalf of Michigan defendants is P57434.
Thank you, counsel, and good morning to you. I appreciate your indulgence as well. All right, so the claim's obviously been properly joined before the court. I don't know that I've set up any scheduling order. I see that it looks like there are some initial items, initial disclosures that have been made. All right, so gentlemen, updating me, my information is perhaps formally open discovery, give you some opportunity to proceed in that way. If you feel that there might be some shortcuts in that regard, let me know. Let's talk about it.
Certainly, Your Honor. This is a first-party no-fault case arising out of an accident that happened on December 25th of 2021, when the Henry Ford's patient, Sagiana Clark, was hurt in an accident. There's about $14,000 in unpaid medical bills. She didn't have any insurance coverage. An application was made with the Michigan Assigned Claims for coverage, and when that wasn't paid, suit was filed. I don't think we need a lot of time for discovery. I'll leave that up to Eric. I think 90 days would be plenty.
Yeah, Your Honor, I agree with that. Our only issue, first, this is was assigned to Citizens Insurance Company in the Midwest, so it has been assigned, and I suppose we can deal with that either later, or we can amend the caption. But the only issue we really have is that we have had no contact at all with Ms. Clark. All we have is an application that was presented by plaintiff, and we have had no involvement from her. So we'd like to take that deposition. It might take a little while to find her, but we'll get right on it as soon as we get discovery.
All right, very well. So I'll go ahead and set up a period of discovery. I'd like to review the matter shortly after 60 days. So basically what I'm going to do is I'm going to set this up to come back in January. So we're looking at January 23rd, 2023. I'm going to set this on to 9:30. Discovery will be open through that date, and I'll review the matter at that time. Also, that day you'll get a written discovery order from the, or a written scheduling order, I should indicate, a written scheduling order from the mail. That scheduling order is going to set forth the date once again, the 23rd of January 2023 at 9:30 a.m. Also, under paragraph 6 in the scheduling order, it's going to give you the opportunity to file any motion that you wish to be heard in front of this court. This does not preclude filing motions in the future, but it gives the opportunity to bring matters before me that you might want the court to hear, whether it's positive or not positive. The only requirement is that you set the motion for hearing on that date. The only requirement actually is that you give the other part at least 10 days notice. The other part is 10 days notice of the motion. So in other words, notify the other side 10 days before the hearing of the motion, and I'll hear it on that date. Now, this is different, of course, from what typically allowed under court rules, you could actually file a motion for summary disposition if you believe that that's something that you could appropriately do. And I'll hear it on the 23rd of January, as long as the other side has at least 10 days to respond to the motion. So if you set it early enough for the other person to have 10 days, I'll hear it on the 23rd. That's just positive or not. If you've got some motion that's dealing with some discovery issue, if it has to come to that, get it in, set it up 23rd, we'll address those issues on that day. And again, I know that the case may not be won by that time, maybe it will, maybe it won't. So this does not preclude filing motions in the future. We'll address that on the 23rd of January. But if you can accelerate the case in any way, if there's some issues that are right that need to come in front of me, go ahead and schedule it on that date. I'll address any issues at that time. And then go forward from there. Okay, so you'll get all of that. It will be in the scheduling order. I just wanted to point your attention to paragraph number 6, because that's where you see the language regarding the following motions. So until the 23rd of January, 9:30 a.m. I bid you farewell, gentlemen. We'll see you at it.
Thank you, Your Honor. Have a nice day.
Thanks, Judge.
Good. All right, the court now calls case number 22-191-506. This is LBNB Funding LLC versus Kimberly Johnson. Before the court on the filing of a complaint regarding collection of a debt, it appears. There's also been the submission of an answer in regard to this case. So the matter is joined before this court for a status scheduling conference. Your appearance for LBNB Funding, please.
Good morning, Your Honor. Keith Sparks here on behalf of LVNB Funding P77485.
Thank you, counsel, and good morning to you. I'm looking now for Kimberly Johnson. If you're on the Zoom, say something at this time, please.
Good morning.
Good morning to you, Miss. You are Kimberly Johnson, is that correct, ma'am?
Yes.
All right, good morning to you. I did receive your answer to the complaint that's been filed in this matter, Ms. Johnson. All right, you were pointing out as a part of the filing of your answer is that the debt is over, or the account is over 10 years old, and you were objecting to the account because of that issue. Is that correct now?
Yes.
All right. All right, counsel, tell me a little bit about that, if you will.
Yeah, so the account was opened in November of 2014. The last payment on the account was in June of 2019, and the account wasn't charged off until January of 2020. So while the account itself is, 8 years old or whatever it may be, the Credit One Bank card that the account relates to wasn't charged off until 2020.
Yeah, and under the law, there is a 4-year period after the charge off in which the case can be brought, and that's why this case yet survives, Ms. Johnson. It's not 10 years old. It's certainly 8 years old, but it's not when the account is open. It's when the account is no longer in use, when the account is charged off. That's the point at which the lawsuit can be brought. And there appears to be sufficient time to have brought this action. I guess a part of the reason that I raised that issue is that this case involves a claim for about $1,500. I'm wondering if at this point the parties might be able to talk about this and find a way to get this resolved rather than this linger for the next 90 days or 6 months. I know $1,500 is a lot, but it's not $15,000. Ms. Johnson, are you prepared to talk about maybe looking for a way to get this resolved, ma'am?
Yes.
So, counsel, I want to take a moment. I want to send both of you to a breakout room and see if there's a way forward. And again, I have other tools to work with, but I do think that it makes sense at this point, given that the statute of limitation is not run. The case is still a good case. It can be brought. That maybe there's a way to find a way to set this up, trying to pay it off, or some partial payments or something. You all talk about it and see if you can reach some agreements. If not, or either way, you're going to come back to the court with that. So there's your notification, ma'am. And counsel, I'm sending you a notification as well to breakout room 1. Just click in and you'll be able to speak privately and talk about this case.
Thank you, Your Honor.
All right, the court now calls case number 22-189052. This is Beaumont Health versus Sheila Rutland. The matter is before the court for a status conference. The record should reflect that I received a complaint alleging damages in the amount of $4,123.02. And I received an answer to the complaint. There was an application for default that was filed in the interim regarding this matter as well. Your appearance for Beaumont at this time, please.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Thank you, counsel, and good morning to you, Mr. Burke. Thank you for your patience this morning. I believe that there was a person on this Zoom, Ms. Rutland, and I just saw where she dropped out. Did you speak with anybody on this case this morning, counsel?
I did notice that somebody dropped out, and that was not, I don't believe that was Ms. Rutland, and I have not spoken to her today or candidly at all on this case. I know she was properly served, and I defer to you if she was given notice of this hearing. I think she probably was.
I'm looking at the notice that went out, and it's reference to an address on Monarch Street. That is the address that is consistent throughout this this case. And I'm comparing the addresses are the same. I'm looking at the defendant's response to the complaint, and in her response, she uses the address on Monarch as well, 501. So our notice went to that location indicating a time of hearing at 9:45 p.m. Let me just check with the clerk. The young lady that was that dropped out, was that she Monarch?
You know, when she was on the phone, and she was trying to put her name in it. So that's the one that was arguing, saying that the phone was not dying.
Did she ever say what her name was?
No. No, she learned how to mute, but she never unmute to answer. And I think that's where she was having her trouble with.
All right, well, and as you might imagine, counsel, I'm dragging just a bit to see if that person is going to call right back in. That's been about 5 minutes ago, and they have not called back in. We did not get that person's name. So it seems to me then that the defendant has not appeared in this matter. Also, the answer in this matter are a set of general denials. There are affirmative defenses that were raised, raising issues of statute of limitation, failure to mitigate damages, alleging latches and unclean hands, certain equitable defenses. And counsel, tell me just briefly why this claim would not be time barred.
Your Honor, you broke up at the last part of your question, but I did hear most of it. My reply to you is this. This is an unpaid medical bill. We believe that none of this has been paid. We believe we have the right identity and that Ms. Rutland was the patient. Her answer, although I know you were quoting some of it, I believe was boilerplate, and I respect that. Of course, I'm not certain why she's not present. If you consider a default under the 7-day rule, maybe that will give her some time to reply. However, I defer to you if you'd rather reset it one more time and see why she didn't appear. The address that we have, I believe, is the same address that she was served and noticed to be here. So I defer to you, though.
Yeah, and I was concerned about the obviously it is boilerplate language, but if it hits the target, then it becomes significant. But you raised the issue of claims being time barred, And I'm looking at the generation of expenses or billing by the hospital on the exhibit A that was attached to the complaint. And it looks like the billings were generated 2019 through 2021. And I can't see where there would be a time bar where there are bills that relate to 2019 to 2021.
I agree with you. In fact, before any of these cases ever get to court, we monitor them so that that won't be raised. And I believe that this is within the statute time.
All right, and so, given that there was an answer filed, and given that the court has set a date, I thought I'd take a look at that to see if there was some substance that might, that might really stand out. And obviously, if statute limits, you can't get any, really get any one bigger than that. And certainly, bills occurring in 2019, 2020, 2021 would not be time bar. It appears that the defendant has not appeared. The court did give notice. The notice has gone to the proper address in this regard. The defendant will then stand in default regarding the status, and the court will sign a judgment based upon that default on its presented to the court.
Thank you, Your Honor.
So, counsel, go ahead and present something. I do have a previous item that was presented to the court back in August, but I just assumed that you submit an updated proposed judgment to the court.
I will do that, Your Honor. Would you like me to do it under the 7-day rule or just submit it directly to you?
7-day rule, if you would, so I would really appreciate that. You could also email that to the court so that they can begin the process. And that email.
I know you have a different clerk.
Carmen is the first name. Carmen dot Banks at 36 District Court.org.
Okay, and is Carmen CARMEN?
MEN, yes. Dot Banks is the last name, BANKS.
At 36
District Court.org.
Thank you, Your Honor. I will do that. Thank you.
Thank you, Counsel. Good day to you, sir.
Have a great day.
Right, you have to look at the purses and like.
You tell me what night is.
Right. A lot, I get that a lot. They be like, no. All
right, so we're back on the record regarding the suffix 1506, that's LBNB funding versus Kimberly Johnson. Parties went out to talk and break out rules regarding this matter. And Mr. Sparks, go ahead and update the regarding this matter.
Yeah, so the parties actually reached an agreement, and our office is going to mail Ms. Johnson a consent judgment. It's going to be for the full amount of the 1453 plus court costs and interest, but there's going to be language in there that states that the parties do agree to settle for the amount of $1,000 to be paid at $50 a month beginning on January 15th of 2023.
All right, and Ms. Johnson, is that what you're agreeing to? A judgment to be entered with certain costs, but you have the opportunity, privilege to pay it off at a total amount of $1,000 in monthly increments of $50. As long as you keep up with the payments beginning in January, that you'll only pay the $1,000. If you don't keep up with the payments, then the amount can be accelerated back to the original amount, and the parties can seek to collect on that judgment. That's your understanding of the agreement, ma'am?
Yes.
Anything you wanted to tell me about that? Any questions that you have of me?
No.
All right, so what I'm going to do, what I'd like to do is I'd like the attorney to go ahead and prepare that. And I want to ask you if that order says, or that order says exactly what you agreed to. Is it okay if the attorney signs your name to it as consent based on your agreement on the record? and send it to me so I can sign it and send it back. I'll only sign it if it says what we agreed to.
Yes,
It's okay with you, do it that way, ma'am?
yes.
And I promise you, when it comes out, it will say exactly what the agreement is here. Otherwise, I won't sign it. If you see something in there that's different from what you agreed, then you keep the Zoom number that you came in today. Come back in on Zoom and say, Judge, this is different from what I agreed. We'll get the attorney back on and we'll figure it out, okay?
Okay, thank you.
All right. So that's gonna be the resolution. Council, get that over to me right away. You can send it to Carmen.Banks, CARMEN, Carmen.Banks at 36districtcourt.org. And you can initial it for Ms. Kimberly Johnson, indicating agreed on the record. And I'll look at it and sign it, get it back out to you, and we'll send copies to Ms. Johnson as well.
Thank you very much, Your Honor. Thank you, Ms. Johnson.
Thank you, Council. Thank you, Ms. Johnson. Good day to the two of you.
Good day.
Deborah?
Hey,
How are you?